All right, everybody. Let's do Tinker versus Des Moines Independent Community School District. All right. This particular one deals directly with student speech in regards of not just what is being said, but most importantly, the concept of how it's being said. All right. It's the concept of how, not the what. All right. We got to make this clear delineation between the two. It's extremely important to do that. All right. Now, this particular court case deals with a lot of other concepts. It ties into what we deal with at school when it comes to our newspapers and where it comes to our news at our school. So it has a lot ramifications to it. So let's get directly into it. All right. Let's look at some of these turbulent times in which is going on currently at this time period, 1969. Now, the country was basically embroiled in a major conflict regarding the Vietnam War. Uh, we had a situation in regards of the ending of Lyndon Baines Johnson presidency, linking directly into Nixon's presidency, and we went to war in Vietnam. And this conflict was not approved by Congress, but from a police action that escalated over time. So Congress never specifically got us into a war. Remember, we talked about the power in which Congress has a couple of months ago in regards that Congress is the one acting body that can approve the United States military to go into war, not the president or anything of that nature. But the president got us into Vietnam off of a specific conflict. And this conflict instantaneously and quite quickly escalated into war over a period of time. And this is one of the main reasons why many people were just so upset and irritated and frustrated with how government was running at the time overall. Also, keep in mind that many did not want to fight in this conflict with unclear war aims or basically why we were going to war, the result in which this came to be, as well as the perspective that people were legitimately trying to dodge the draft, right? It's People were literally dodging the draft because remember we didn't have a whole bunch of individuals in our army, in our national guard, in our navy, in our marine system because we just got out of a conflict not too long ago, which was World War II. And not just World War II, we also were in Korean War. So we didn't have what you would call able bodies, right? So because of this concept, the draft came to be. And this is where I told you before, where like Muhammad Ali was drafted and he said he wasn't going to fight based upon his religious beliefs. He was stripped of his heavyweight title in boxing and was basically sentenced to prison time. You also had a lot of other individuals who didn't believe in the war, whether it's because of religious conflicts and religious aspects or anything else, specifically dodged the draft and they went to prison and so on and so forth. Now, the country was just divided on this war, and many youth actively protested. And what I mean by actively protested, I mean they went out on the streets and protested. They went to their congressmen and congresswomen. They went to the senators' offices in their towns, even in Washington D.C. They protested in front of the White House. We had individuals that were doing illegal protesting, like pipe bombs and threatening officials or government officials because of this. It was a very trying time over a elongated period of time in the mid to late 60s going into the early 70s. Now, I put this here because it went to the Supreme Court eventually. Remember, the process in which it happened where essentially you have all three were involved. And what I mean by all three branches were involved, I mean the legislative branch was involved because initially, we got troops into Vietnam to try to de escalate issues, which led into a war. Congress was involved because they never really approved the war, but still trying to figure out how can we specifically get out of the war, yet and still have a draft to mitigate the losses that we were obtaining in Vietnam. And of course, the Supreme Court to see the conflict involved, how constitutional this issue happens to be. This leads into the essential questions at hand. The essential questions are one, what is symbolic speech, right? What specifically does speech entail as it regards to symbols and symbolic perspective? When is symbolic speech protected? So, in other words, if our speech and what we say out of our mouths are protected, at least to a certain degree, is symbolic speech protected as well? And symbolic speech is basically the concept of symbols on what we wear, how we wear things in regards of protesting, shirts, hats, things of that nature. But also, how does a school identify disruptive speech? So it also deals with the school concept. Is that does the school? How can a school determine if a particular type of speech is disruptive, right? It is highly, highly important to understand this concept. Um, and the same time, how disruptive is disruptive, right? So, is disruptive the concept of just blatantly and outwardly harming the educational process in a school? Is it a subtle nod or a turn by saying, oh, that's interesting, and students and administration and faculty continuously look at it, trying to decipher what the message happens to be on a consistent basis, yet the school day continues to run with a little snickering and snares and so on and so forth? Or is it the concept of as long as you wear it and there's no backlash, no one's really involved in this perspective, um, no one is being hurt, whether it's mentally or spiritually or verbally? What specifically is disruptive, right? And we're going to tackle these things in this particular PowerPoint. First, let's go to the facts of the case. In 1965, John and Mary Beth Tinker attended a public school in Des Moines, Iowa. Right, this school was a public school. It was a very highly educated area within Des Moines, where a lot of individuals were there that believed in America and American ideals, yet and still freely allowed individuals to wear what they wish as long as it doesn't pertain to harmful nature of the school or the area or the perspective of America. And basically, what I mean by that is any type of paraphernalia or what so on and so forth that doesn't put a holy look or view from one aspect of the population upon said person, right? You're able to wear what you wear, you're able to say what you wish as long as it doesn't disrupt, quote unquote, the environment of the school system. Now, Tinkers were part of the group protesting the Vietnam War, right? So they didn't appreciate the Vietnam War. They didn't like it. Um, they felt that the Vietnam War did not represent the ideals and perspective of what America truly happens to be. So, with that, to publicize their opposition to the Vietnam War, they wore black armbands to school. In other words, they had normal clothes, jeans or slacks or khakis, shirts and match and so on and so forth. But they came to school with an armband, or a black armband with the peace symbol on it, to protest the concept of the Vietnam War. Now, the principals in the school district created a rule, at least at that time, during this time frame, that any student wearing an armband to school would be suspended unless the armband was removed. So the principals within the school district heard about what was going on at this particular high school, and all the principals worked together and came up with a rule to solidify the fact that if any student comes to school wearing this particular armband, this black armband with the peace symbol on the armband itself, that if it's not removed, they will immediately and expeditiously be suspended from the school for a particular time period. So, what do you think the Tinkers, and by the way, one of their best friends, Chris Eckhart, actually did? They protested. Even more so. They were defiant of the principals themselves. They went out and protested themselves. They protested the concept of peace on earth, not to get in wars we had no business being a part of. Many of these peace signs that you see in the top right were handed out, and many of them protested that concept as well. You also had individuals, they were also protesting, even from the far left, that we want to fight another rich man's war, right? So you had all these concepts happening. And not only did they do that, also they decided to continue to wear the armbands itself in a form and gesture that was, quite frankly, just defiant of the rules of the president. I'm sorry, president, of the principal and the vice principals and the school district itself. So on the top left are the Tinkers, the brother and the sister, and those are the armbands in which they wore. In the middle picture, the black and white middle picture, is Mary Beth Tinker still wearing an armband, and her mother. At a school board hearing regarding their armband and the concept of them being suspended from school and continue to be suspended from school while they're wearing an armband. And the bottom left is Mary Beth Tinker with it in the 90s at this time frame, and a cartoon on the far right about the Tinker case. I know you can't really read that well. I'll provide that particular cartoon to you all once I post this in Google Classroom. Eventually, the Tinkers finally returned to school, and their fathers filed a suit in the U.S. District Court. So the suit itself basically stated that the Tinkers and their best friend, Chris Eckhart, that the school district violated their individual rights to protest and violated their First Amendment rights in regards of free speech. Even if free speech itself meant not saying anything verbally, but specifically talked about the concept of showing their displeasure to many people throughout that particular area of Des Moines, Iowa. and even to the point of when it got to national news, showing it off. So they said that the First Amendment rights of their children were violated and shouldn't have happened. Not just that, they asked for damages and what we call an injunction. And this injunction was to stop school officials from continuing the armband policy. One, when we talk about damages, right? The concept of suing them to take care of their legal fees from suing the school district, and on top of that, the injunction, so they're able to continue to wear the armband, yet go to school and receive the education in which they deserve from the public school system. Now, the district court decision, when it went there, said that school officials' policy was reasonable, right? And the main question when it comes to reasonability here is that what were the school officials hoping to avoid, right? And the district court basically stated that what they were hoping to avoid was mass chaos in a particular school system, knowing that it was that the United States were kind of on edge in regard to this of the Vietnam War. Too many protests and too many people were getting hurt on the streets. People were very leery of the issues at hand and didn't want to escalate it in Des Moines, Iowa, any further than what it has already been. The Tinkers appealed the case from the district court to the U.S. Court of Appeals. This ended in a tie vote. So you might ask yourself, if the U.S. Court of Appeals ended in a tie vote, in other words, you had one judge that believed in the Tinkers case, one judge that believed in the Des Moines, Iowa school district case, and the third judge was unable to decide based upon the merits of the case. So you had a tie. So you might be asking yourself, which decision was enforced? And ironically, the decision from the district court was upheld. Excuse me. So, which means the students still had to take the armbands off if they wanted to go back to school and get their education, because the policy from the district court ruling said it was reasonable for the school district to have a policy with the intent that that any situation wouldn't have escalated to the point of harm of other students and other people in Des Moines, Iowa. And they were concerned that major harm would have occurred once these students would have worn these, and not just that, harm in the school system, because you still had students who believed in the war versus students who didn't. So they did want to get to that particular point or that level. All right. Also, what would be the next step? The next step would be the Supreme Court. So since the district court stated that the school system was okay in regards of this measure, that they were just fine having this particular measure at the school system, and the U.S. Court of Appeals couldn't come to a reasonable decision to either continue on with the case or end this case in theory, the Tinkers decided we're just going to take it to Supreme Court and let Supreme Court deal with it themselves. All right. Now, I put this chart here so you can see exactly how it happened and what happened. U.S. District Court, the district court sided with school officials, again declaring that the regulation against armbands was reasonable in order to prevent disturbances in the school. In other words, some form or fashion of whether it's fights, major disagreements, or disruptiveness in the classes or out the classes itself. The U.S. Court of Appeals for the Eighth Circuit was equally divided in the case, so the district court decision stood at this time, and it led to the concept with the Supreme Court. All right, so let's move on with this concept. So, what types of symbolic speech is protected overall? Okay, so number one, does it matter that the speech was in school? Technically speaking, no. But also keep in mind that it's not clear to what extent hate speech is protected also. Remember, we talked about this before in class, right? The perspective that we have individuals like the KKK, the individuals that are racist or pronounced racists that talk about, killing and disrupting the nature of black people and enhancing the white race, or even extremists on the opposite end. There is no specific concept to signify the fact that hate speech itself, as vile as it is, should or shouldn't be protected. In other words, the concept, right, of hate speech is protected as long as it technically doesn't harm the body or the people within said community or communities. So this is where I talk about that it's not clear to what extent hate speech is protected, yet and still they have some protection along the way. Now, what types of expressive acts are considered speech? Does this particular concept refer to the perspective of expressive acts? And technically speaking, it does. And what I mean by expressive acts is being able to express a disdainment, an anger, or a particular feeling about something, whether it's in a community, whether it's in the society, or whether it's dealing with the nation or the military. These armbands with the peace symbol on them represented some form of expressive acts which can be considered free speech. All right? And not only that, did the armbands cause a serious disturbance at the school? Which is another question that the Supreme Court justices had to take into account. Did these cases, or this particular case, cause some form of disturbance where it was almost impossible for the administration to control the school, as well as, or possibly, the teachers would be unable to control the narrative in their particular classroom? And also, were all political symbols banned, right? So if you ban the concept of a armband with a peace symbol on it, does that mean you have to ban the Iron Cross, which is basically a Nazi symbol, which technically was allowed at this time period, and KKK members were using it significantly and still using it to this day? Or it may be even the swastika, which is vile and vilified now, but any type of political symbols, would they also be banned? If we ban a peace symbol on an armband, is it necessary and proper to disband all forms of political symbols? So all these questions had to be answered by the Supreme Court, but argued by the lawyers. So let's take the size of the cases The plaintiff, which was Tinker, and the defense, which were Des Moines School District. Okay, Tinker. Students are entitled to free speech too, not just adults, right? Young people have a right to express themselves freely without repercussions to them. If you don't allow them to have free speech, you are denying the fact, denying the concept of free speech overall, and saying that the the free speech of adults are the only ones that matter, which is false and wrong. All right. Next, First Amendment protects our right to free speech. It's important to understand that the First Amendment itself provides all people, not just adults, but even students, free speech. That free speech does have a cost to it. As long as that speech itself does not denigrate individuals to a certain extent, and that free speech expresses the feelings of the individual based upon the time, nature, and situation that's going on, the First Amendment protects it, whether we as individuals like it or not. Also, other symbols, which happens to be more hurtful, are allowed in schools. Take, for instance, our history books, right? You open the history books and you see the concept of swastikas and the iron cross in our textbooks, because these are forms of history that we have to look at and view. So that's important to grasp, because if we get rid of these armbands, you also have to get rid of all these other symbols in our history books. Also, the First Amendment protects the rights of the people. So the First Amendment itself also protects individual rights. No matter if we like said person or said people, the First Amendment is there to specifically protect the rights of all people, no matter the consequences and situations. And they also state on the Tinker side that the 14th Amendment offers equal protection. So they also state that even though they dislike the concept of hate speech, the iron triangle, the swastikas, and all these other concepts, it is still protected under the 14th Amendment. And we also have to put some form of disclaimer on these symbols in order to understand the meaning behind them, right? So 14th Amendment offers equal protection. The First Amendment protects our rights, individuals. The First Amendment also protects our speech itself, whether it's hurtful, harmful, or neither of the two. Now, Des Moines states that they must be concerned with the safety and welfare of all students, no matter if it's a free speech perspective or not. The rights, the safety of the students are important. And knowing that this concept of the Vietnam War is a divisive issue from the start means that these armbands can escalate the high tensions that have already going on within the school district. But also, Des Moines states that schoolwork could be disruptive. Now, I need you to highlight, understand when you write down your notes, the word could. What I mean by could is they're saying that it wouldn't necessarily disrupt, but the possibility of disrupting the classroom and the school environment is there. And that alone is a problem within itself. And then the primary purpose of school is to learn and to be educated, not the issue, not the issue of protesting and enhancing the rights of free speech upon people. The last concept they argue is that there could be threats of violence on school grounds. Now, this goes outside the scope of the school, right? Individuals specifically, individuals specifically that are adults can see these young kids and view these young kids and what they're saying and possibly attack them because they are showing that they are against the government, aka the military, aka the president, right? So other cases that work along these lines. We spoke specifically about Schneck versus the U.S. of 1919, right? That individuals could be punished for disturbing um, or distributing, excuse me, anti-war pamphlets, um, which caused a clear and present danger to the war itself and to individuals vying to fight in the war, which was at the time a free speech issue. Another case which we didn't talk about is Thornhill versus Alabama in 1940, which was picketing is a form of symbolic speech, right? So having signs and dressing up these signs by saying, you know, you know, the concept of, no hate, or the concept of no war, just peace, and things of that nature, right? That's a form of symbolic speech that should be utilized and should be viewed as free speech. West Virginia versus Barnett, 3 years later, a Supreme Court case that freedom of expression is allowed in schools. So they're saying this case stated that young people, whether it's elementary, middle, or high school, even college, they all have the right and the freedoms and the perspective to be expressive in school overall. That's an important concept to understand, right? So not only do we have Tinker versus Des Moines, Tinker are using the cases such as Thornhill versus Alabama and West Virginia versus Barnett, while Des Moines School District is using Schneck versus United States in 1919 as a court precedent to value their particular side of the argument. Let's look at Morris versus Frederick. And the reason why I'm putting this up first, or next, excuse me, is that it's very important because this case follows the case of Tinker versus Des Moines. And what I mean by that is that the Supreme Court ruled that the First Amendment would prevent educators to suppress speech at a school sponsored event if speech could be promoting drug use, right? Supreme Court stated straight up, the First Amendment itself would prevent educators or administrators to suppress the speech of any student at any particular public school if it sponsored an event if speech could be promoting drug use. All right. This was a 5-4 decision. And this is important because it also shows the limitations that students have when it comes to free speech. All right. Um, but also would be able to limit what educators and administrators can do and can say to students in the concept of expressing themselves. So in this case, does two things. One, enhances the freedom of speech for young students and even students in college, but at the same time, able to limit what administrators and teachers can say and can do in regards of their students' ability of free speech when it comes to certain issues, in particular, drug use. Here are the justices at the time in regards of this case. This case is kind of transitioning into a new era. As you see on the very far left, it was 9 white judges, um, which leads into now we're going to have in the middle Thurgood Marshall is coming into play as a Supreme Court judge, and then later on, not too far thereafter, on the cover of Time magazine, you start to see the first female Supreme Court justice in the great Sandra Day O'Connor. So the vote, who actually won this case? In the 7-2 decision, go ahead and just put all this up here. So it's kind of messed up my PowerPoint here. All right, 7-2 decision in favor of the Tinkers, right? And the majority opinion was basically this: students keep their constitutional right of freedom of speech while in public school. So their freedom of speech not doesn't just stop at the school doors. It continues on inside the school doors. The concept of highly regarded conversations in schools and being responsible citizens and being able to express themselves freely, fully, without any equivocations whatsoever are important. School officials must provide constitutionally valid reasons for regulating school expression. In other words, the school system in the schools itself must provide a valid reason as to why they need to suppress students' ideas, viewpoints, and ideology. It must be explained explicitly. In other words, if you wanted to write an article based around how the school or how any school is being ran, you can do so. However, the principal administration have every right to deny it. But while they deny it, they must provide a valid reason as to why you, the students, cannot be able to express yourself fully within the school newspaper. School officials must show material and substantive disruption with the discipline and education of students. In other words, they must show beyond a reasonable doubt, right? The material that's being disseminated, the information that is being sent out, it's not only disruptive in the classroom, but it's equally disruptive throughout the school system and the school itself. Next, the majority opinion also says wearing armbands was a silent and passive expression of opinion. In other words, you can wear clothing or symbols of expression that protest something as long as it's silent yet passive within its expression. It's indiscriminate, in other words. And of course, another form of the majority decision stated that students do not shed their constitutional right to freedoms of speech at the schoolhouse gate. This last part is so critically important to you as students and to any students thereafter, right? You can express yourself freely without any questions or any equivocations whatsoever. Your right to free speech doesn't just stop at the schoolhouse gates. it continues in the schoolhouse gates also, just as equally as it is you're able to express yourself at home, the mall, the barbershops, the hairdressers, and so on and so forth. Now, the dissenting opinion or the minority vote says, look, and I pull this quote because it's so interesting and so powerful. The myth to say that any person has a constitutional right to say what he pleases, where he pleases, and when he pleases. In other words, they're saying that to say whatever you want to, however you want to, in the manner in which you want to, it's just a myth. It's a figment of your imagination. It's like it makes zero sense because there's always consequences to what you say and how you say things. So it is important to grasp that concept. So if you say certain things, you have to note that there are going to be consequences to what you say and how you say it and the manner in which you say it. Also, the armbands were a distraction, taking students' minds off their schoolwork. In other words, what they're saying is this. They're saying that one, the students who wore the armbands, the students who wore the armbands themselves were distracted because they knew they was wearing the armbands and they knew how people would react to it. So it was a purposeful act. But not just that, it was also disruptive because people were literally wondering why are they wearing these armbands? And instead of being focused on the schoolwork, the two Supreme Court justices believed that they were that people were concerned and thinking about the armbands and what is the symbol and the meaning thereafter. All right. So the next concept was that the ruling too restrictive on school officials, limiting control over their schools. Basically, that the ruling they've had specifically states that it restricts the power that teachers and administrators have overall. So, Justice Hugo Black and Justice Harlan, the two individuals that voted against this concept, ruled or believe that you are going to harm the viability and the power in which the the teachers and administrators have. That is detrimental. Um, they're saying specifically this concept is a detriment to the educators that's there to keep order in the classroom and to educate the students, and the administrators to be able to keep peace within the school system, the school itself. Also, there must be recognition of authority of schools and school officials. So Hugo Black and Justice Harlan state specifically that if you limit this concept, school officials no longer have the authority. Excuse me, their authority is harmed long term wise, which is a problem. And we don't want that concept to occur. So they were looking out for the viability and the power and to maintain itself in a school system. So in this case, students' rights are affirmed. Students' rights are upheld as opposed to harm themselves. All right. All right. There we go. This is the ending of this particular um lesson itself of Tinker v. Des Moines. Um, so what I'm going to do is I'm gonna post this up. You have questions, you have comments or concerns in regards of Tinker versus Des Moines, please let me know. I'll be more than happy to assist you. I will have I have my notes as well as information regarding this case up as well. So you're able to view it, see it, analyze it, and understand it fully. Next case we're going to discuss will be the New York Times versus the United States, in which the New York Times newspaper sues the United States. And we'll get into that later on. All right? So, please let me know again if you have any questions, comments, or concerns. And I'll have everything up pretty soon. I will talk to you all later. Please be safe and be responsible. Thanks, guys.